All right, so we're going to go ahead and get started. Hello, everyone, and thank you for coming to the law school's first legal app showcase. My name is Keith Robinson. I'm an associate professor here at the law school, and I'm also the co-director of the Center for Law, Science, and Innovation. I had the honor this past fall of teaching the law school's Designing Legal Apps class. In just a few moments, you're going to hear from 3 student teams that were enrolled in the class and about the legal apps that they were tasked with creating. But before I ask them to come up, I want to say a few words about the course. So a few years ago, the dean of the law school, Jennifer Collins, asked me and my co-director to develop a plan for the law school's first academic center, the Center for Law, Science, and Innovation. One element of that plan was that the center would support faculty in the development of new courses at the law school that would prepare students to practice law in the digital age. Because of a generous grant from the center, the law school was able to provide this innovative course to our students. Now, designing legal apps sounds cool, and if you ask the students, I think they will say that it is, but it's much more to it than that. It's much more to the course than that. We have a growing problem in this country. Only a tiny portion of the population has access to legal services. In addition, even large corporations that have the ability to hire expensive lawyers are putting pressure on law firms to provide more efficient and cost-effective services. Thus, legal apps present a huge opportunity for the legal market to serve clients across the economic spectrum. Not only have we seen evidence of legal apps closing the social justice gap, but large law firms are also using legal apps to serve their clients. Because of this opportunity, we see an explosion in the number of companies that provide legal solutions through the use of technologies such as artificial intelligence and advanced software. One such company and our partner in this endeavor is Logic. Logic provides software that allows professionals such as lawyers to build AI-powered applications to automate their expertise. So the 8 students that you're about to hear from are on the cutting edge, I would argue, of legal practice. You might read about artificial intelligence and how it's affecting law practice. These 8 students lived it for a semester. They were split into 3 teams, and each team was paired with a legal aid organization. For their final project, they were asked to build an app that will help this organization in its mission. Over the course of 15 weeks, these students were asked to learn how to use very complex commercial software. They had to meet with representatives from legal aid organizations that serve clients in our communities, and they had to work together as a team to build a working application. Most importantly, they had to come up to speed very quickly in vastly different complex areas of law. I think if you ask these students, one of the most rewarding things about this class is that they got to build something. They got to build something tangible, which is what they're about to present to you. And these tangible things, these apps that they built, will eventually be used by other lawyers to help people in the Dallas area and the state of Texas. So before I bring the students up, I just want to say a few quick thank yous. I want to thank Tanina Rostin, who is a professor at Georgetown University Law Center, for her guidance in helping me bring this class to SMU. Also want to thank from Logic, Kelvin McCulhay and John Lord. I want to thank Luke Grossman, who is my TA. And then 2 faculty members in particular that I want to thank. I want to thank Mary Spector, who was very helpful and instrumental in helping me bring this class to SMU. And I also want to thank Dean Jennifer Collins. Finally, I want to thank my co-director, David Taylor. All right, so with that, we're going to proceed as follows. I'm going to ask each team to come up and give a short presentation of their app, And then after they're done, we'll take maybe a few questions, about 5 minutes of questions, and then we'll go on to the next presentation. And hopefully at the end, maybe we'll have some more time for you guys to ask questions of these teams. I'm extremely proud of all these students and what they've accomplished in the semester. So the first team I want to bring up will present to you the Texas Fresh Start Advisor Act.
Hi everyone, I'm Chris Cochran and this is my teammate Richard Spar. During the fall semester, we had the pleasure of working with the student attorneys at the Judge Elmo B. Hunter Legal Center for victims of crimes against women. By using the software, the Neota Logic software, we created the Texas Fresh Start Advisor application to help human trafficking survivors. Before we dive into the application, however, here are some statistics to demonstrate how large of an issue human trafficking is. Human trafficking is an international problem. Approximately 21 to 24 million human trafficking victims internationally. Approximately 4.8 million are victims of sex trafficking, and that is approximately a $99 billion industry for sex traffickers. Approximately 20.1 million victims are victims of labor trafficking. Approximately 16 million of those are in the private sector, and 4.1 million are in the state labor. Labor trafficking is approximately a $4.2 billion industry for traffickers. Human trafficking is also a problem in the United States. 1 in 6 endangered runaways, or minors, are victims of sex trafficking. The average age of a labor trafficking victim is between 12 and 16. 61% of these victims are female, and 39% are male. The life expectancy for victims of trafficking is only 7 years. Closer to home, human trafficking is also a problem in Texas. There's approximately 313,000 victims here in Texas, approximately 79,000 of which are minors and youth engaged in sex trafficking. Approximately 234,000 are victims of labor trafficking. Traffickers exploit approximately $600 million per year from victims of labor trafficking in Texas, and the most at-risk industries and economic sectors, including migrant farm work, construction, kitchen workers in restaurants, and landscape services. An estimated $6.5 billion is spent on the lifetime costs of providing care to victims and survivors of minor and youth sex trafficking in Texas, including the costs related to law enforcement, prosecution, and social services. Here are some headlines that have been in the news since we set out on this endeavor to create this application. One of them comes before the semester started, but it was interesting, so I decided to include it. Many human trafficking tragedy survivors clinging to life. July 24, 2017. Human trafficking. North Texan shares her survivor story here at SMU at a conference on September 24, 2017. 4 arrested on charges of sexual assault, human trafficking. October 23, 2017. Grapevine teen sold in 20 states. Here's her story. November 17, 2017. Investigators alleged sex trafficking led to Sherman teen's death just this week, January 11, 2018. Now I'm going to pass the microphone over to Richard to share some more.
I'd like to introduce Nicole. Nicole was 15 years old when she was lured into the harsh world of sex trafficking by her abusive boyfriend. Over the next 15 years, she was routinely beaten, deprived of basic necessities, and sold out for sex. During that time, she collected 50 drug, prostitution, and loitering-related charges, all for crimes she was forced to commit. By some miracle, Nicole managed to escape her tormentor and began to attempt to re-enter a normal life. For rescue victims of sex trafficking, finding a safe place to live and securing a steady job are essential to rehabilitation. But finding a place to live without a job and multiple criminal convictions is near impossible. Nicole tried to find employment, but she had no luck. She can remember one employer telling her that she just wasn't a good fit, but she knew the real reason. Nicole tried to get her record expunged, but she described the process as near impossible. After being a long-time victim of the sex trafficking system, Nicole became a victim of the legal system. Is it fair that Nicole has a criminal record for crimes she was forced to commit? At least one study found that 80% of employers utilize criminal background checks during the employment process. Good luck getting a job with one prostitution charge, let alone over 50 charges and convictions on there. As long as women like Nicole carry their criminal records with them, they remain current victims of the sex trafficking system they were supposedly rescued from. Trafficking survivors deserve a fresh start and a future full of possibilities without the stigma and pain from the experience they have with human trafficking. Survivors need all the help they can get, but there just doesn't seem to be enough help to go around. Where would a survivor even start? Sure, there are some free resources out there and clinics willing to take cases pro bono, but they are overwhelmed by the need, the substantial need of survivors out there. Many survivors are not even aware of the possibility to get their charges and convictions erased from their record. And if they are aware of the possibility, they have no idea where they begin to achieve this result. Recently, January was designated National Slavery and Human Trafficking Prevention Month, so it seems fitting that we speak about this issue and project with you here today. Chris and I were fortunate enough to be teamed up with several students at SMU's Hunter Legal Clinic. The center provides representation to survivors of gender-based harms, including domestic violence, sexual assault, and human trafficking. One of the center's focuses on post-conviction relief. The students recognize the need for expanded access to resources for victims who can be benefited by this type of relief. And together with these students, Chris and I were able to develop an online application that will hopefully assist with this process. Through a short series of questions, Texas Fresh Start will allow Hunter Legal Center caseworkers to efficiently work through the client's arrest and conviction records and determine whether the client is eligible for an order of non-disclosure or an expunction. Hopefully, Texas Fresh Start will allow women to navigate through some of the complicated legal issues associated with these crimes and give women exactly what the name of this application implies, a fresh start. So where did we begin? Chris and I began with these flowcharts. What are these? These are flowcharts. And when starting this course, we were told that part of the process would be sitting down with our team and sit with them, understand the law, and build these flowcharts. Essentially, what these charts represent are the many avenues and possibilities that a caseworker or a victim would have to navigate in order to determine whether or not they were eligible for an order of non-disclosure or an expunction. Essentially, what our app does is break down all this information and compile it into an application that allows these victims to focus on the narrow issue of their particular case and ultimately give them a resolution. My partner Chris is going to walk us through an example of how our application does it.
So this is the link to our application. This is Texas Fresh Start, hosted by the Neotologic server. And then going to it, we're going to use Nicole, who Richard just spoke to about, as our example. If you remember, she was convicted for a Class B prostitution charge. So on this first page, she gets information about what the system is about. And if she isn't familiar with the nomenclature of order of non-disclosures and expunction, we've embedded the functionality where you can just click on the term, and it pops up and gives you a little definition. And this is throughout the application for several terms. I'm not going to click on it every time it's there, but just whenever you see a hyperlink, know that that is an avenue for them to get more information. So if Nicole were doing this by herself, or if she were sitting down with a caseworker, they would click to get consultation. There's then a disclaimer saying that this is only for informational purposes, and it's not designated or intended to provide legal advice. And if they have questions, to consult an attorney. First question asks whether they were found guilty or were found not guilty of the offense. Since Nicole was found guilty of her prostitution charge, she would click no and continue. Then asks whether she was placed on, if she was convicted or placed on deferred adjudication for some of these more serious offenses. None of hers are involved, so she would click next. It asks whether it's the first misdemeanor, subsequent misdemeanor, or felony. Nicole is dealing with the subsequent misdemeanor, so she would select that choice and move on. It would ask if she was placed on deferred adjudication. She wasn't. No. It asked if she was confined, convicted, or failed to complete her probation. She was. So the system informs her that she's likely not eligible to receive one type of an order of non-disclosure. She may, however, be eligible for a human trafficking OND. And if she wants to continue at this time and determine if she's eligible for that, she can click yes. If she doesn't, she clicks no, and it'll take her to a screen giving her resources even though she is ineligible. And I'll show you that screen before the conclusion of our presentation. So clicking yes, it takes us into asking whether she has received an OND previously as a survivor of human trafficking. No, she wasn't. Offense, she was arrested for prostitution, so she would select that. It then asks questions pertaining specifically to prostitution. It asks whether she committed the offense solely as a victim of human trafficking. She did. If she was placed on probation, if the conviction was set aside, and if she was then placed on deferred adjudication, convicted of another crime after being placed on probation, besides getting a traffic ticket. Selecting no brings her to a final report that tells her she is likely eligible for an order of non-disclosure. Of course, this doesn't constitute legal advice, so we provide resources for them to reach out to find attorneys who may be able to help them more with their case. And as I said, if at any point Nicole had indicated that selected answer indicated she was not eligible, or if she was not interested in determining her eligibility for a human trafficking order of non-disclosure earlier, she would be taken to this screen, where it would say you're not eligible. But once again, this is just informational. She could have selected something wrong and may actually be eligible, which is why these resources are here, so she can speak to an actual attorney who may be able to help her with her case.
Thanks for that, Chris. That just about concludes what we have for you. We'd be happy to field some questions if you have.
What sort of maintenance do you guys have to make sure that all the information stays up to date as the law progresses?
Well, it's going to be a continuing project as the class continues into further semesters. So we kind of left a carryover memo, kind of where we ended and what we expect may happen in the future app-wise. But obviously, we don't know how the law is going to change. So that'll be up to students who are in the class to work with the Hunter Legal Center to figure out what changes there are and what changes need to be made to the application, so it stays relevant to human trafficking survivors.
Given the age range of most of the victims that you cited earlier, did you do any readability analysis to determine if they're even capable of understanding the language that you code?
We did a little bit. We tried to use the most basic language we could, but obviously there's always room for improvement, and that is something that people could look at in the future as well.
Now, I forget the specific name of the application we used, but we did run it through a readability sort of analysis to determine whether or not the school was high enough to be presented to the general public. And at the same time, I think we envisioned that a lot of this would be done with, at least initially, with caseworkers in the clinic. But as this app progresses, I think that is an issue that future students will have to address. All right.
Sorry.
Was any testing done with clients of the clinic?
No, it wasn't. We just strictly went through it with the student attorneys to make sure it is what they wanted and everything. And obviously, this is still version 1.0. There's many versions to come. Anyone else?
It seems like in both cases, if they're eligible or not, the result is the same. That you just say consult legal advice. This is not actual legal advice. In version Infinity, what's the goal of this? Is the goal that it's processing the appeal for them? What's the ultimate thing? What's the ultimate product that's going with?
I mean, I don't think it would have to take a fundamental change in how the legal process works, where we require people who are licensed as lawyers to be giving what actually constitutes legal advice. So until then, we couldn't necessarily rely on an application to do that. So it depends on how that change comes. Maybe if that change does come, this would one day be capable of doing exactly what doing the appeal and everything like that.
But first of all, there are slight differences, because I made the mistake of just copying and pasting the same line the first time. And our clients quickly pointed that out.
But I think you'll see that the software is actually very powerful. And with some of these other applications that are about to come up, you'll see that forms can be processed and the app can essentially be full service. Like Chris said, this is 1.0, and I think as we get further down the line, that could do some really cool things. But we'll get to show you all some other features with some of these other applications that our classmates built. All right, thank you.
We have one more.
Oh, well, okay, one more.
Sorry.
Very quickly, I'm sorry. Was it your intention, your contemplation that the victim/user would always be using this in conjunction with the caseworker?
Ideally, if they are capable of doing it themselves, or they'll will be with a caseworker. But going to the earlier question, the language may not be capable right now of someone who's young using it by themselves. But ideally, at some point, they would be able to do this on themselves. There's also mobile functionality. You can use it on your phone, which one of our classmates will demonstrate. So, they'd even be able to do it just on their phone real quick, just something as simple as that.
All right, thank you guys very much. All right, so this next group is the Texas Appleseed Consumer Debt Act team.
Hi everyone, my name is Alex Ron, and we worked on the Texas Appleseed Answering Consumer Debt app. First, Josh is going to walk you through a little bit about consumer debt and problems with it, and then I'm going to walk you through about the purpose of our app and what our goals were in creating the app. And then last, Courtney is going to go ahead and walk you through an actual use of the app. So Josh, do you want to get us started?
Thank you. So together with our wonderful partners at Texas Appleseed, using the software tools provided by Neurologic, we sought to create an application to assist defendants in consumer debt cases. So you might ask, why would we help defendants in consumer debt cases avoid these debts? And oftentimes, they've either paid off the debt doesn't belong to them, or there are other circumstances that basically make collecting this debt unjust. And as you can see, Texas has the third highest percentage of adults with a debt currently in collection. And Texas is a very large state, so that's a lot of people. Additionally, a lot of these defendants fall into the justice gap, which means they can't afford an attorney, but they also don't qualify for free legal services. Most of these cases are brought in the justice of the peace courts, where normal evidentiary rules do not apply. And this aids the debt collectors because often this debt is bought and sold so many times that they might not even have the correct evidence to prove that the debt belongs to the defendant. However, they can still win and get a default judgment when these defendants don't show up in court. And now Alex is going to speak to you about the goal of the application.
So as Josh was just saying, they will get a default judgment if they don't show up to court or if they don't file an answer. So with our app, we wanted to help with the ability for these individuals to at least file an answer so that they don't receive that default judgment. So it was honestly a tool that these individuals could have, and it would give them a resource where if they couldn't get actual legal service, especially since it is a justice of the peace court, they could do all of this process on their own. So we did this by creating an application that would ask the individuals questions, and by the end of our application, it would email them an actual answer form that they could then send into the court, but also bring with them to court. And Texas Appleseed provided us with the sample form, and so then we took that form and worked backwards when we created our questions in order that this app would produce a similar form. And one of the neat things about it is that, for example, we have a pleas section and an affirmative defense section, but underneath like a plea that they would potentially bring, it will say why they were bringing it. It would give them a little bit of information about why they would bring that plea, so they're able to talk to a judge about it if they do take that form with them to court. And a lot of what Texas Appleseed told us is that people don't file answers or don't show up to court because it's a lack of confidence, and it's a lack of not being scared to deal with this process. So they see the form or the letter sent to them and they just get rid of it or throw it out because they don't want to deal with it because that's easier and this is scary and someone wants to take them to court. So more than anything, we wanted to provide them with an easy to navigate, easy process that would give them the confidence to get through this answering and showing up to court. So one of the ways that we did do this too is that we understand that people don't want to sit down a lot of times for 25 minutes and work through an online form. So one of our main goals was to make it so they could split up the process and sit down for 5 minutes and do part of it and 5 minutes and do another part of it. So we split it into 3 sections: general denials, specific pleas, and affirmative defenses. So an individual can go on and choose to do one or choose to do all 3. And we do recommend that they sit down and complete all 3, but they do have the option of just doing the first one and then coming back and doing the second one. So after they finish the first one, they can say, oh, I want to take a break, I don't want to do the other 2. And when they do that, it will email them that first part of the answer. The only thing, and we explain this to them, but the only thing is they will have to then compile those 3 sections with the 3 emails that they get to be their full answer. But it will allow the individuals to not have to complete the entire app in one sitting. So now Courtney is going to go ahead and walk you through at least one portion of that, I believe 1 or 2.
So as Alex said, it's composed of 3 parts, and these are our decision trees that went into driving the process. As you can see, it's very complex behind the scenes, but when you get in front of the user, they see this simple, easy to follow form that's really streamlined, and that does encourage them to sit down in 30 minutes and have this answer that they can walk into court with. We're going to use Miss Sherry Storm as our hypothetical and hear her story.
I opened the door and an envelope was thrown at me and the guy said you've been served and left. Supposedly it was a debt that I owed. It was right under $5,000. It was with a company I never had a card with. It's humiliating. It's intimidating. It provokes a lot of anxiety.
So Ms. Sherry Storm could get to our application, and when she's greeted by this short synopsis that, as Josh explained, it tells her about the process and kind of the situation she's dealing with, and that she can complete all 3 parts in less than 30 minutes. When she clicks on, she will meet succinct instructions that tell her this is a free service and encourages her to do it all in one sitting. It also tells her that it will provide her an answer that she can be confident in. When she goes to the next page, it'll ask her if she has an email address. We will use mine just because I don't know Miss Sherry's. And when we go next, it'll ask if she's already completed a portion of this application, as Alex had mentioned. If she has, she can skip parts, but we're going to go with no, she hasn't completed and start from scratch. Naturally, because we're future lawyers, there's a disclaimer. And then she's ready to begin. When she first gets to the beginning, she will answer basic information to provide for her answer document, such as her name, her address, and her phone number. When she goes to the next portion, it'll ask for information such as cause number and who is suing her. As Chris's and Richard's have, we actually have a hover function rather than a click function. So if she gets to cumbersome terms that she's struggling with, she just hovers over it so it can better explain to her where she will find this information on the answer or the petition that she received. Further, when it asks who is suing her, it'll tell her about what a plaintiff is and where she will find this. We're using Port Coal's department store because they're also located in Wisconsin as our test company, and then she plugs in all the information that she can find on her petition. After supplying base information, she will reach the specific pleas portion. Going to the specific pleas portion, it will ask, does the company suing you legally own your debt? Several of the more daunting questions that she might struggle with provide the option of I am not sure. This ensures that Ms. Sherry Storm does not waive any legal rights that are due to her. And it gives her much more confidence in the process and a sense of comfort. As Alex had mentioned, there is specific portions throughout the application that explain, for example, is this one of your situations? There is hint text throughout the application, which is one of my favorite features. Anyone can sit down and use this application. Any education level. I had my mother sit down who barely had high school, and she was not good with technology, and she was like, oh, it tells me what this is, I could do this. And I mean, even my mother was confident in the way that, which was a big thing, because she's very technology cumbersome, bless her heart. But anyways, and so on completion of all 3 parts, the specific pleas, the general deniability, and the affirmative defense, Ms. Sherry Storm will receive an email that contains her form and an answer document that she can not only file with the judge, but walk into court and read confidently on. It'll have her case number that she supplied. It'll talk about the plaintiff, Coles Department in our case, and have her name, her address, and all her party information. Further, it'll include the specific pleas based on her responses that she wants to plead, as well as defenses, affirmative defenses that she thinks she could claim in this case. As we saw with the video, Sherry Storm said she was humiliated and she was intimidated. This application provides her not only a legal document that she can file with the judge, but something that she can stand on with comfort in a fearful situation. A confident document that she can read from. It provides, her signature that she can turn in and know that she is able to have a starting place against this unfair debt. And now we would be delighted to answer any questions about pertaining to our act. Yes.
How does the "I'm not sure" choice affect your decision tree? Does it take you to both options, or?
No, sir. So when they select "I'm not sure," because it's a justice of the peace, they can claim it. And as I believe Josh said, it has an explanation that she can read from. And if the judge is like, that doesn't really apply to your situation, then they just set it aside. But it gives her the option. It's almost as if she had said, yes, it does apply to her.
And that was something that Texas Appleseed did recommend that we include, because we had, I'm not sure, but they wanted that I'm not sure to be something that would automatically include them getting that plea on their sheet, because if they don't put the plea down, then they automatically can't bring it. And they would prefer that they have it rather than not have it, and they can actually talk to the judge about it to find out if it is a plea or an affirmative defense that they can bring.
What if the person doesn't have an email address?
Then at the very end, I can walk through all three parts, but at the very end of the application, at the very end of the application, at the very end of the application, it comes up with a report very similar to Chris and Richards, and at the very bottom, it has a Word document option, a PDF option, and several ways that they can download the report, and it is also mobile friendly. So they can pull it up on their phone and have it to read from in court if they need that. But if they don't have an email address, it gives them the document to download. Yes, Ms. Becker?
The decision trees look very complex. Are those decisions that the consumers would have to make on their own if it weren't for the app?
Yes, absolutely. They had the answer form that Texas Appleseed gave us was a hodgepodge of 7 pages, and it was like, it just had a list of each of the defenses, and they had to go in and just check whether they had that defense or that plea. And I mean, as I said, we had worked backwards from the form. We were like, what is this defense? What exactly does it mean? We had to figure it out.
Court is supposed to be easy.
Easy, yes.
Right? Well, and a lot of the pleas have, a lot of the things will help you, the same things are part of the qualification for those pleas. So we were able to kind of streamline it and say, okay, so this one question will make them qualify. If they say yes to this, will help make them qualify for these 3 pleas or these 4 pleas. So it helped kind of streamline the process, whereas someone who sits down with a sheet that is full of just things that they've never seen before, it can be really overwhelming.
Can't wait to use it.
Yes.
I know some of Professor Spector's research has learned that some debt collectors actually use the county courts of law instead of the justice courts. Is maybe one of the notes to future students to see if this can be adapted, or maybe it can just be used as is.
We did provide 3 different options for the type of court. So this was just the justice.
Oh, you were just showing them, okay.
And we did get the information we used was from Texas statutes. So it is based, it might not be the form that they could actually file potentially, but it is something they could bring to court with them at least, I would assume.
Well, probably what I was thinking is, even if you got somebody who doesn't want to take the time, although it's not that much time, to do the special pleas and the affirmative defenses, all the general denial says is we deny each and every all in singular, but I mean, it requires no personalized information, and it would stop statute of limitations, and it might be enough to make the collector go away if they're dismissing any case that gets a response. So I just wondered if since you can amend without needing permission for a long time in Texas courts, whether that option ought to be made, highlighted more.
That's also,
Made more easily available.
That's also one of the reasons we split it up into 3 sections, so
Yeah.
you can complete just the general denial and submit that.
Well, one of the questions I would have is an issue of privacy. So I'm, the person that's filling this out, and the very first thing is you ask for all of my information. And I might be concerned as to how that's used in various ways. Would it be wise, and I don't know the answer to this, to put that information at the back when they now know what it's going to do, and if you want the material for the court, then ask for that personal information instead of starting with that? I mean, I probably would stop on page 1 because to me, there's no guarantee of privacy once I give all that information out.
Well, this link, I believe, will be provided off of Texas Appleseed's website, and it gives a whole rundown of, you can fill out this form, or you can do this app, which would completely form for you. I mean, in our instructions and theirs as well, it completely explains, like, this is here only to help you and provide an answer rather than not answering. And as Josh said, the majority of people don't show up and don't answer. So through their website, they give a lot of information about what this is and what it's going to do and how to craft the form for you.
And the general denial portion is just your basic information portion, besides the one question that asks if you would like to deny the debt. So it's only one question that's a part of the general denial portion.
Do you have any ability, either through the app or otherwise, to capture outcomes so that you guys or some future students could come back a year from now and say 80% of the people who use this form?
So as concerned with security, we don't save any of the information. Texas Appleseed does not retain any of the information. It is solely the privacy of the individual. But it's, as they say, version 0.1, who knows? Yes, Terry.
You mentioned earlier text-to-speech. Is that, you talking about how you use that? It was on a board earlier, text-to-speech form. Did you use that in your app?
That was the end result in the final. So like specific pleas, like this is the check marked box is the actual specific plea that would be what was filed. And then the bullet points underneath are things that they could say in court to better explain that plea and or defense. Yes?
Based on how long it took you to do this for Texas, how much time do you think it would take to make it available for every state if someone was to go and use the structure of the app and then change the decision tree?
I think you would just, Josh is pretty great at this app.
The only thing you would really need is experts in the field for each state. And then all of the questions are very easily changed.
And one of the things that we had thought about Texas Appleseed is going to be creating videos in the future that go along with a lot of this information to like inform people about it, and maybe future classes will be able to include little hyperlinks where people can go and watch a video about the question that they're asking and things like that to better like help them understand the process that they're going through. So that's maybe 2.0 or 3.0 include videos and things like that.
All right, thank you guys so much. All right, this last team, you guys probably have the coolest name at least. This is the Texas Know Your Rights Fire App Team.
Good afternoon, everybody. We are the fire team. My name is Jesus Velasquez. This is Mary Summers and Caroline Shivers. And our app was created for a coalition of organizations, including the Catholic Charities of Dallas, the ACLU, the Equal Justice Center, and the Workers' Defense Project, and also including others helping the immigrant community in Dallas. Texas currently has one of the highest immigrant populations in the country. Unfortunately, many of them don't know the rights protected in the U.S. Constitution. As we know, the U.S. Constitution protects everyone, regardless of immigrant status, from discrimination based on race or national origin. Everyone is entitled to certain protections, including the right to be treated fairly in court, free speech, religious freedom, and other core civil rights.
So the Texas Failure to Identify statute makes it an offense to refuse to provide your name, date of birth, or address when you're arrested. What is not an offense is refusing to provide your name, date of birth, or address when you are lawfully detained. However, if you are either under arrest or lawfully detained, it is still an offense to provide a false name, date of birth, or address. In Texas, police officers and ICE agents often think they have the right to identify anyone at any time for any reason. Know Your Rights information that immigrants may use from other jurisdictions does not take into account this Texas law. Therefore, many immigrants do not know the rights they are entitled to under the U.S. Constitution, taking into account the Texas Failure to Identify statute. Our act helps anyone, but especially immigrants in the community, to understand what their rights are in various contextual situations.
The Texas immigrant population has a large number of Spanish speakers, so the app provides both an English and a Spanish translation. The app also lets users indicate one of three timing situations: right now, before, or after, as well as one of three locations, whether it be at home, in the car, or in the street, and the type of law enforcement, police, and ICE.
We knew that most of the users would be accessing the app on mobile devices, so we had to make sure the text and design elements were mobile optimized for use on a small screen. Since information in the app also needed to contain large blocks of text, we had to present the information in a way that would keep the reader from becoming overwhelmed. We addressed this by adding signposts to our reports to let the user know how many screens there are until they reach the end of their desired scenario. Now I'm going to start our demo. So I created a hypothetical end user for this presentation named Josie. She has two sons, Chris, who's 10, and Jonathan, who's 14. Josie heard about a friend who was taken to a detention center when ICE came to her house. Josie wants to be prepared by learning about what to do when ICE comes to your home and making sure that her sons also understand what to do. So first, Josie is presented with information about what the app does, as well as a privacy policy. The fire organizations wanted us to encourage users up front that no information about their immigrant status or anything else was going to be taken and collected in the app to encourage them to actually get through and use it. So Josie's going to select the answers that reflect her situation. She wants information about being prepared, so she's going to go with the before scenario. This indicates that she is not in a time crunch and she can read more, look at videos, has a longer path to the end of the app. She's choosing home and ICE. You can see that signpost I mentioned. She has 9 screens until she reaches the end. On a before the moment path, there's more information as well as more kinds of information. Like I said, the user's not in a time crunch. So Josie can read through the bullets, broken up to keep you moving and feeling like you're making progress throughout the text. There's both instructions and then statements to tell the law enforcement officer as you're in the encounter. And video presentation of some of the same information that we received from our fire organization. The video sort of puts this into a context with a scenario that's shown. And so you can watch that video and then you can see some of the things that you're reading in action. Josie continues on the longer path. A little more information. The information is presented in the chronological order of how encounters work. So you see someone, you encounter them, what do you say, what do they say back, you say this, and then as the situation can progress up to the point of maybe being arrested. Because at that point we assume people don't have their device any longer. These are some optional downloadable files that Josie can access and get more information in another format that can help with just the scale of the app, in the mobile format, but also having extended information about lists of information that she should have compiled, and then things with examples of warrants and valid or invalid warrants. Because ICE warrants and police warrants can be confusing, and so this is to help that a little bit. So Josie reaches the end, she gets more information about fire organizations in case she has another issue and she thinks one of these might be able to help her as well. She can directly into an email to those organizations. And then if she says, oh, there are these other options, I should go through and look at another one, she can just click start over and she'll be back at the beginning. Josie's now equipped to prepare for an ICE encounter at her home and can practice with her sons on what to say and do to stay safe while protecting their rights.
So we're going to walk you through another user. His name is Mario. Mario was on the street walking home when a police officer stopped him and tried to ask him to identify himself. Mario says all he was doing was walking home and he was not committing any crime. Mario tried to exercise his right to remain silent, but the police officer was aggressive and demanded Mario state his name. He believes his rights were being violated. He wants to report that information to help others avoid a similar situation. Mario also wants to get more information about how to successfully exercise his rights in the future. So then we'll go through it again with the intro and the privacy policy. And so here, since he's reporting it, we want to do an after situation. So he was in the street, and he was encountered by the police. So here, in the after situation, he's given a few additional questions. None of the questions are asked really information about himself and any privacy issues, but it's for more of the fire committee to kind of understand what type of situations are occurring. So he thinks that he was stopped and detained illegally, yes. Also, these, you can click on them and it can provide more information on what being detained illegally means if he were to not know that. Likewise, he's not sure if he was legally searched, so we put a I'm not sure situation. And he does think that he tried to exercise his right to remain silent. He's also given an area where he can type in information where he thinks that might be valuable to the fire committee. And also, in all the reports, we ask the user to record any encounters they have with police or ICE. And so therefore, right here, this is an option for him to upload any audio that they may have recorded during the encounter. So then we're taken to the report, and so since it's already occurred, we have a little bit less screens, 1 of 6, than we do the before. But we also provide him with general rights, certain street-specific rights. Also, again, we have to click so that you can learn more information. Again, he gets information about protecting his rights on the street specifically. Here's more information about what to do. And then he's also given the option of how to keep and file a complaint. And he's given additional resources of how he can contact any of the fire committee teams. So with each report, the app generates an email. So this, for example, is an email that is sent to the fire organizations. This email does not contain any personal information from the user. However, the email allows the organizations to see which information is most commonly accessed and permits them to tailor educational resources according to the data.
And finally, we will show you the app's shorter in the moment path. We use this mobile emulator to demonstrate the portability of our app in case of an emergency. So our last fictional end user will be Maria. Maria was a passenger in a vehicle with her husband Robert driving to take her child to daycare when they get pulled over by the police. Maria has no idea what to do now, but luckily she had heard of the fire app, so she decided to pull it out and use it. Maria speaks Spanish, so she's going to go ahead and click Spanish. And after the first 2 introduction screens, she can indicate that she needs help now. In a matter of seconds, she can access a succinct set of instructions and information regarding her traffic stop. Maria can also access information about the rights of her husband and her child, which is included in this little column. The In the Moment path was designed to inform users of their rights when they don't have much time to react. The text on the report is catered to the most crucial information needed in a situation like Maria's. We've shown you 3 paths through our app, but there are many more combinations. And that concludes our presentation, and we'd be happy to answer some questions.
Does it have a place to upload video and audio, or was it just audio? It's just audio. It would be very easy to add a video function. However, since we mentioned in the instructions to the user to record audio, that's what we started with, but easily a 2.0 feature that could be added.
I guess this is a question more for all the teams. I happen to notice all of you use a Macintosh computer. So I was just wondering have you checked all those forms and drop-down menus actually work on other browser or other form, like for example PC, Edge.
We have checked other internet browsers. Has anyone use a PC? So, yeah, it has to use on a PC. Since it's a web app, it should work fine either way. Josh is confirmed as our resident
pro.
Courtney, did the app translate everything for you, or how did y'all deal with the multi-languages?
So we had to physically go in there and manually enter in the language. It would be nice
if it could sort of integrate with the translator program on your computer, that you would like edit that instead of have to bring all of that in yourself. The Neurologic app building software does give you an interface that you can use to translate, which lines up all of the things in English and all the things in Spanish to make sure that they're correct. You can do it with as many other languages as you'd like. So that's something that we talked about with the organizations. Obviously, there are immigrants from other places that are not Spanish-speaking countries, and so getting other languages ported on would be another step we'd like to take in the future.
On your user app, this one, I cannot imagine that if you're being pulled over, that you would have the time to fill out all of the previous information about language and other sorts of things. Is there a way that you can build that in so that they are preloaded and ready to start using the app so that it's just immediately, are you being pulled over, are you at home, or?
Well, part of the function that we're trying to provide is context-based advice. So when someone's in a car, it's a different situation from when they're at their house, and it is a different situation whenever it's police versus ICE. So we have to get those few questions answered. As soon as we get someone on the I Need Help Now path, we make everything as short as possible. However, there's sort of the 2 functions going on at the same time. If someone is worried, I will not have enough time to read the ideas that hopefully they've had an encounter with someone who's used the app and can say, let me share this with you, go through all the information, print out the downloadable files, and use that before time when they're not in the moment to really take things in. In our scenario, we have a passenger in the car, so I think that's also one thing in terms of it being a driver versus a passenger. That was something else we wanted to maybe delve deeper into with the new functions going forward.
Yes.
Yes. If you suggest recording these encounters, would you consider the mobile app as just a switch to immediately turn recording on?
Sorry, can you repeat that?
So if you suggest that these encounters be documented or recorded, I was wondering if on the mobile app you considered a switch to immediately turn on audio and video recording.
That would be something we'd have to check in with the app software if you can integrate that function of actually turning on the audio. I know they anticipate people uploading the audio, but also if you are on your device, it's a matter of pressing your home key and turning on that other app. So So it's usable now, but also I think could get that integrated in the future. We'd also hope that in the future, depending on the Toyota logic changes in their development, that it could be an actual mobile app with a little tile on your home screen, as opposed to a web app, which is their functionality they offer right now.
Do you have the ability to insert your own code on top of theirs?
No. In limited ways. I was able to embed a video with the desired link, so very, very small aspects.
Didn't you try?
The goal of the application is to avoid coding.
There are a lot of things that bar you off from, but they also worked with us a good deal to make the changes and accommodate what we had our ideas and stuff.
I actually had a general question for all of you guys, if that's all right. So it seems like all these apps that you guys present today are for some sort of marginalized sector of society. And even though there might be free clinics or lawyers doing pro bono work, they're largely underrepresented. And so I was wondering if you guys were tasked at all for finding some sort of revenue model for keeping these apps updated, or is the idea to really just reach the masses with as low cost as possible, I guess? I mean, it seems like the second group is the only one that really has like a tangible product that you could really charge for, but
we did design this to be public sort of resources for the public service organizations. They have other apps that Toyota has worked on that are profit models. And I think they're within law firms, a lot of them right now. But
Right, yeah, so as I mentioned in my opening comments, there are major law firms using this software to design apps that generate revenue, right? But the good thing about legal aid organizations is that they will allow us, and they're gracious enough to allow students to sort of go down this path with them and experiment with them. And the benefit of that is that these students got a chance to learn this incredibly complex software and solve a discrete problem. And the legal aid organization, the way it works is that these apps probably, I'm aiming for the end of this month, these apps are going to be turned over to the legal aid organizations that they would vote for. And the legal aid organizations will be tasked with maintaining them with some assistance from us. And so we will continue to help them update the apps and evolve the apps. But the other part of this is, you're exactly right. There is a revenue model here, and I think I feel incredibly grateful and proud, and I'm extremely excited for these students because they have this skill now that they'll be able, a marketable skill that they'll be able to go out into the legal market with.
And we'd all like to thank Professor Robinson for bringing this class and
We're about at time, but any other general questions? If not, I'm going to hang around for a little bit, and maybe one or two of the students can hang around. We'd be happy to do a in-person Q&A. But thank you very much for coming and attending.
Autographs.
This world is too fun and life's too short.
We love
Okay.